arbitrationagreements.org. Today we will dive into the question, is arbitration binding? The answer, in short, is both yes and no. Before we explain, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. Arbitration is a process where disputing parties agree to submit their disagreements to an impartial third party, known as an arbitrator. This arbitrator then renders a decision, often after reviewing evidence and hearing arguments. Now let's delve a bit deeper. Arbitration can be of two primary types, binding and non-binding. In binding arbitration, the decision made by the arbitrator is final. Both parties have agreed, typically in advance, to accept the arbitrator's decision and be bound by it. It's noteworthy that approximately 8 out of 10 commercial disputes resolved through arbitration are through binding arbitration. If you're part of the process, this statistic indicates that the odds are your case will be binding. On the other hand, in non-binding arbitration, the arbitrator's decision is advisory. That means either party can reject the decision and choose to pursue other remedies like going to court. This type might be used as a preliminary step to give parties an idea of how an independent third party might view their dispute. However, it's important to know that even in cases of non-binding arbitration, approximately 3 out of 4 decisions are voluntarily accepted by both parties. That goes to show that more often than not, the parties find the decision reasonable and choose not to prolong the dispute. Now, you might be wondering, why choose arbitration over traditional court litigation? Well, for many, the process can be quicker, less formal, and sometimes less expensive. A study from 2019 found that the average length of an arbitration process in the United States was about 8 months, while traditional litigation in courts often take multiple years. Remember, arbitration can be either binding or non-binding. The key is to understand the type of arbitration you're entering into and the implications it holds for the dispute at hand. For more information, head over to arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Successful companies depend on arbitration to save money. You're paying one service per case instead of experiencing the uncontrolled expenses of a standard lawsuit. That's the key reason why arbitration is so popular. Also, what do you think about binding arbitration? Does binding or non-binding arbitration make more sense for disputing parties? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.